Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Hello guys, my name is Airlangga Frimasti with MPN 201000380 from Kelas. Today I will present the result of my presentation about criminal law. First, what is criminal law? Criminal law is the body of the law that relates to crime. It prosecutes conduct perceived as the threatening, harmful, or otherwise endangering to the properly health, safety, and moral welfare of people, inclusive of oneself. Most criminal law is established by statute, which is to say that the law are enacted by a legislature. Criminal law includes the punishment and rehabilitation of people who violate such law. So, difference between civil law and criminal law is civil law and criminal law are two broad and separate entities of law with separate sets of law and punishment. Civil law deals with the disputes between individuals, organizations, or between the two in which compensation is awarded to the victim. Criminal law is the body of the law that deals with crime and the legal punishment of criminal offense. Okay, next, the definition of criminal conduct. The principle of legality is recognized in almost all legal systems through the world as the keystone of the criminal law. It is employed in four senses. It first is that there can be no crime without a rule of law. Thus, moral or antisocial conduct not prohibited and punished by law is not criminal. The law may be customary as in some common law countries. In most countries, however, that only source of criminal law in a state. Nullum crimen sine lege. No crime without a law. Okay, the next objective of criminal law. Five objectives are validly kept for enforcement of the criminal law by punishment, retribution, deterrence, incubation, rehabilitation, and restoration. Jurisdiction differ on the value to be placed on each. First, retribution. Criminal ought to be punished in some way. This is most widely seen rule. Criminals have taken improper advantage or unfair determination upon others, and consequently the criminal law will put criminals at some unpleasant disadvantage to balance the scale. People submit to the law to receive the right not be murdered, and if people contest this law, they surrender the right granted to be by law. Thus, one who murders may be execute himself. A related theory includes the deal of the right, the balance, and then deterrence. Individual deterrence is aimed toward the specific moral offender. The aim to impose a sufficient penalty to discourage the offender from criminal behavior. General deterrence aims at society at large by imposing a penalty on those who commit offences. Other individuals are discouraged from commit those offences. Okay, next, incapacity. This is simple to keep criminal away from society that the public is protected from their misconduct. This often achieved through prison sentence today. The death penalty or punishment have served the same purpose. Next, rehabilitation. aimed at transforming an offender into a valuable member of society. Its primary goal is to prevent further option by convincing the offender that their conduct was wrong. Okay, the last is restoration. This is a victim-oriented theory of punishment. The goal to repair through statutory any injuries inflicted upon the victim by the offender. For example, one who embellishes will required to repay the amount improperly acquired. Restoration is commonly combined with other main goals of criminal justice and is closely related to concept in the law, returning to the victim to his or her original position before in the jury. That's all for me. Thank you and see you goodbye.